For electricity in Queensland.
Good to have your company this morning. I'm not surprised we're getting flooded with texts and calls over the sentencing for the murder of Emma Lovell by the courts yesterday. And as I said, we are on standby for the sentencing in the Kefu home invasion as well this morning. I believe the sentencing hearing is underway. So as soon as we find out something, we'll let you know. We've been talking about this a lot, and there's been a predictable level of outrage and shock at the sentence handed down to the teen who stabbed North Lake's mum, Emma Lovell, through the heart, and she died, and then he fled the scene. It was also revealed by the judge that he left her to bleed to death on her front lawn, laughing after police found him nearby. The 14-year sentence with a non-parole period of nearly 10 years is believed to be one of the highest given to a juvenile offender, after Justice Tom Sullivan found the crime to be both violent and particularly heinous. But to many, it's not enough. We've been talking about that this morning. Mrs. Lovell's family, like all victims of crime, they face a permanent change to their life as they once knew it. It has many of you asking, and we've been asking as well, if adult crime should get adult time. Joining us now to discuss that is Associate Professor from Bond University, Dr. Terry Goldsworthy. G'day, Terry. Nice to talk again.
Yeah, good morning, Bill.
As I said, there's been obvious outrage from our listeners this morning and the community in general that seeing too much of this. Simply, I guess the question to you, your response first of all to the sentencing and the premise that an adult crime should get adult time when sentencing has been taken into account. I know there's many layers to this with the judge and with sentencing and charging, so maybe you can explain it.
Yeah, sure. I'll go through it for your listeners. So in Queensland, the penalty for the offence of murder is either imprisonment for life or an indefinite sentence under the Penalty and Sentences Act. Now, in terms of parole, for life for murder, you usually have to do 20 years, although that can be up to 25 or 30 if you kill a police officer or if there's multiple murders. Now, in terms of young offenders, someone who's aged between 10 and 17 years, they may be dealt with as a child under the Youth Justice Act in terms of the Children's Supreme Court. And then the mandatory sentence requirements of life imprisonment or indefinite sentence don't apply to that young offender. Now, if a young person is found guilty of murder, the court can order they may be detained for no more than 10 years, or in other circumstances where it's shown to be particularly heinous, as it was in this case, they can serve up to time of maximum of life, and we saw him get 14 years. There are some circumstances where they can be tried as an adult, for example, if there's an adult co-offender, etc. They're a little bit complicated, those rules. But for your listeners, there has been a study done of sentences of youth offenders for murder by the Queensland Sentencing Council, and they looked at between 2005 and 2015. So 40 offenders who were aged under 18 at the time of their offence were dealt with as adults. They all got a life sentence, so that's more than 15 years jail. The remaining 6 youth offenders were dealt with as children, and interestingly, 2 of them received life sentences, and the remaining 4 got sentences between 8, 10, 12 and 14 years. So the 14 years that we saw yesterday for youth offenders probably sits in the middle, I would say, of the type of sentences we've seen given to youth offenders in Queensland for murder.
Okay. So did you say that 4 that were around that age got life? So this offender, I guess, was 17 years and only 17 years old, but 4 months short of turning 18 at the time of the crime.
Yep. Yeah, so for the offenders who are under the age of 17, because it was, we hadn't raised the age at that stage, they were all dealt as adult offenders and they got life sentences. The ones who were under age 17 years of age and were dealt with as children, 2 of them, out of the 6, 2 of them got life sentences and the rest got those periods between 8 and 14 years.
What did you make of this sentencing, given what you've said there and given this bloke was 4 months short of his 18th birthday, so he wasn't under 17, but he was not an adult classically as well, I guess.
Well, look, I think, he probably should have got life in reality. Going into the circumstances of the attack, his history, etc. I look at the commentary in the media about remorse. I mean, I wasn't in the court to see the submissions in full, but it seems to me the reporting indicates that his remorse centres around the effect on his family rather than the victim's family. So I would have thought that a circumstance as this, with extensive criminal history, going to people's homes at night, armed with knives, and it wasn't the first time he'd gone and confronted people in their homes, he probably warranted a stiffer sentence.
And if there is some sort of precedent there with, as you mentioned earlier, so what was the judge's thinking have been here with this sentencing? Why wasn't it harsher?
Yeah, look, I mean, I guess the judge is the only one who can answer that. He did make mention of the impact on the family, and he did say it was atrocious and created that sense of outrage in the community. So the judge acknowledged, I guess, all of the things that we're talking about to some degree, but he obviously thought that 14 years was sufficient in this case. And, when we say life is 15 years and above, so it may not have been a great extension of the 14-year period anyway. But certainly, I guess, as the husband of the victim said, he's kind of grateful that at least he got 14 years. And I think that, is one positive to take away. He didn't walk away with an 8-year or 10-year sentence.
Is it fair to that the identity also has to be protected because they're not adults? They're under Queensland law?
Oh, look, I've started to, voice my opinion on this. I think that if you're declared a serious repeat offender or you commit a serious offence like a murder, etc., you should be named as if you're above, say, the age of 14, etc. I think the community's entitled to know that there's a 17-year-old who's running around with a knife at home and stabbing people and killing them. I think you forego then the protection of the child's name when they've reached that level of offending.
So this kid was carrying a knife with, I think, an 11.5 centimetre blade, as you mentioned earlier on that fateful night. There's been calls to try the armed suspects to the full extent as adults. How would that go if that was a condition of the way they were treated by judges and brought before the courts?
Well, certainly. I mean, the government could legislate that quite easily. I mean, they've legislated into the homicide section for punishment in regards to killing a police officer or committing multiple deaths, etc. So if the government was of the wish to do this, they could put in their circumstances of aggravation that would then force courts to give a harsher sentence if we as a community thought that was appropriate. And you could easily set that up in terms of legislative amendments. It wouldn't be hard to do at all, I would think.
I've got a question for you as well, so Mike, a legal question as well. So the Kefu sentencing is happening this morning, we understand, and believe we know how bloody that was, that attack. Fortunately, no one died, but Rachel Kefu almost lost an arm, and it's a grievous bodily harm charge. Is that right? Why wasn't was that going to limit the judge in the severity of any sentence that he brings down, as well as taking into consideration time served as well? Why wasn't it, say, I don't know, why wasn't it something stronger like attempted murder?
I guess I'm not privy to what DPP's conversations with the investigators were or with the defence, etc. So whether that was thought to be the more sensible charge in terms of getting a positive outcome for the victim in terms of a finding of guilt, I'm not sure, but it wouldn't surprise me. Sometimes it's problematic to go for those higher charges because you then may get people who will go, I'm going to fight that charge because the penalty is much stiffer. So, as I said, there would have been negotiations or decisions made as to what charge to prefer, even though the facts may perhaps have matched a number of different charges. Sometimes it's, decisions made to go through the path of least resistance in terms of getting a guilty outcome.
Pardon me. So the DPP may have thought, hey, look, we want to go for attempted murder here, and the defence may have said, well, we don't think you've got enough proof and enough evidence to sustain, and so we will challenge that. But grievous bodily harm, yes, but we won't. We'll fight that, and so that may have been the negotiation that happened prior to getting to court. Yeah,
look, all those things could be possible. I mean, police will charge someone with a charge. The DPP will then look at the evidence and decide what indictment to present to the higher courts. And I guess an example would be, often you'll see someone charged with murder and the defence may offer, we will plead guilty to manslaughter. So then you're faced with the choice as the prosecutor. Do you run with the murder with a chance that you may lose it, or do you take the offer that's on the table for the lesser offence? And that can be a really hard decision to make for the prosecution because it's like you've got a bird in the hand and then there's a bird that got away. So and I have seen that happen where, defence have put an offer of manslaughter forward, it's been knocked back, and then there's a trial for murder and that's come back with a not guilty where the person walks away scot-free.
Yeah, gotcha. Do you know what any expectation would be this morning with the Kefu case? The teens have been each pleaded guilty to 8 charges, including serious assault, 4 counts of malicious act with intent, burglary, car theft, as they drove to the Kefu house. And we know, I think you would be familiar with what happened inside the Kefu house. Do you know what we'll expect here this morning?
I would expect a period of sentence of imprisonment. I'd be surprised if there wasn't. I'm not familiar with the intimate history of them, etc., and those type of things. They'll all go into the sentencing considerations, but I would certainly think that we would be looking at some form of sentencing imprisonment term of a substantial period.
Very quickly, would you like to see a stiffening up of these laws to be able to arm judges with greater capacity for these young offenders?
Look, I think, the more discretion we can give the judges and greater options is always a good thing. And if that means, not necessarily downgrading punishments, but sometimes, increasing the amount of punishments they can dish out, then all the options are on the table for the judges to make that decision. And when it's made, we can go, well, okay, you had all of those options and you chose that. So then the decision is quite clear, rather than perhaps what we might see now where the judge doesn't have that option of going high or doing something else. So the more options, more discretion we can give our judges, I think that's better. All
right, great to have your insight. Thanks very much again, Terry.
Thanks, Bill.
Associate Professor at Bond University, Dr. Terry Goldsworthy. 133 882 is the open line number this morning, or text 0499 880 882. Going to take a quick break.